Hey everybody, it's Christopher Small from CMS Law Firm. We do estate planning. We do probate. We do it well. Today, I am here to answer a question that I posed on Instagram earlier today from a potential client meeting that I had earlier today. I figured I would come here and do the answer, and that way it would be more fun. I can share it over there, I can share it here, I can share it everywhere. If you are not following me on Instagram, at the Christopher Small, you get to see fun stuff like this. You also get to see, sort of via my stories, I try to capture things throughout the day. So if you wonder what the day in the life of an attorney is like, especially an unconventional attorney like myself, then go and check it out, because I'm doing all kinds of fun stuff all the time. And if you need help with estate planning, you can just call me and we can talk. Actually, what you can do is you can go to this URL, estatemeeting.com. You can set up a time for me to talk in person or over the phone, and I'll do sort of like what I did with this meeting today. All right. So let's dive into this. If you missed the Instagram post, shame on you. You should be my Instagram friend or follower or whatever they call them, at the Christopher Small. Go check it out. But I had a meeting today with a person whose parents had created a trust, and this kind of trust is called a credit shelter trust. All right, and the credit shelter trust is important in Washington State because it allows you to basically double your Washington State estate tax exemption. The way it works is it says when the first spouse dies, you take their assets, their half of the assets, you carve them out into a separate trust. That trust is then not counted as part of the assets of the surviving spouse, which means you get double exemptions, okay? You get to use the decedent spouse's exemption, and you get to use the surviving spouse's exemption, okay? If it's complicated, don't worry about it. I can make you a diagram and you'll understand it in about 10 minutes. So for now, just rewind this if you need to and listen to it again and again until you get it, okay? What had happened though in this scenario was actually something I had never heard of. And it was interesting. And I was like, well, I'll answer this question no matter what, is what I really wanted to say. It doesn't matter to me. If you hire me to answer this question, I'm going to go look up the answer because it was that interesting to me. Basically, what they had been told or had been suggested as a something to do, because at the end of the day, the downside to this credit shelter trust is the assets that go into the decedent's trust, that first trust, they tend to only get one step up in basis, because once they are pulled out of the estate and put into this trust, then they become owned by the trust literally, and they don't get a second step up in basis when the surviving spouse dies, okay? If don't worry about it if that's too complicated, but basically they were trying to do some tax stuff, is essentially what they were trying to do, trying to get a tax workaround to get the second step up in basis, have their cake and eat it too. And I until today, I had really never thought of a way to make this happen, but there may be a way to make this happen. So what this financial advisor had suggested that they do was to execute a note from the surviving spouse's trust to the decedent spouse's trust for the amount of the exemption, basically like an IOU. Okay, what they said is, when the surviving spouse dies, we owe you this money. Okay, we owe you this what should be going into this trust, and we're going to pay you interest on it. It's going to be like a legit transaction because you need to have the IRS sort of look at it and say, okay, this could happen in the real world, so we're going to be okay with that. And they kind of, I think, thought it was too good to be true, so they wanted to come in and talk to me. So the first thing that I told them was, which you won't often hear out of any attorney's mouth, was, I don't know. That's literally what I told them. But there's more. I said, but I can find out, and I will find out, and I did find out. And so here's the answer, if you want to know. So the answer really is, it is possible. It's just involves a few more steps than they had originally planned. What you can do is, and it's actually kind of cool, I think, take some moving around. And by the way, don't just run out and do this. If you're watching this video, call me, estatemeeting.com, okay? Or go book a time with me at estatemeeting.com. Call anybody else, book a meeting with anybody else. Don't just run off and do this stuff fly by night, because if you mess it up, it's really messed up. But what you can do is, you would essentially, you're going to do a bunch of steps where you're going to be like, this is dumb. You're just moving things back and forth, but this is just the way that you do it. So technically, you would create this decedent's trust because it's a standalone, irrevocable trust. It gets its own tax ID number, acts as its own entity, and then you would transfer the assets into that trust. This is the way that I would do it if it were me. You transfer the assets into that trust. Okay, so boom, you got like this. Let's say like Apple stock. It wasn't Apple stock today, but let's just call it Apple stock. Let's call it like $1 million of Apple stock. Okay, these are just I'm totally making these up right now, so whatever. So we're moving $1 million of Apple stock into this decedent's trust. Okay, yeah, it's moved over. Okay, you have the advantage of the first step up in basis for the deceased person dying. Okay, step up in basis means you get to take that property at today's value. Okay, so if you bought the Apple stock at $1 and now it's worth 10, if you sold that stock, you'd have to pay a tax on that difference, on that $9 of difference. But when you die, you get to give it to somebody at 10. Okay, that's called a step up in basis. So you get your first step up in basis, you move these assets over into the decedent's trust, and then you have the surviving spouse's trustee, which is probably the surviving spouse, execute a note to the decedent spouse. And you basically are saying like, hey, can I borrow that stock? Or can I buy that stock from you is really what you're saying. Can I buy that stock from you? I'll pay you fair market value, whatever it is today, plus I'll pay you 4% every year, okay? However, I wanna make a deal with you. For this 4% interest that I'm gonna pay you, I don't wanna actually have to pay you any of the principal until I die, okay? And then the trustee of the decedent's trust, hopefully we're not getting too complicated yet, is gonna say, hey, sounds like a good deal. We're gonna make some interest, so we're gonna make some cash, and then we are going to also, secure our principal, right? Sounds like a good deal. So they're gonna execute the note, and then the decedent's trust is going to transfer the stock that was just transferred to them back into the surviving spouse's trust, okay? Now, you might be saying, well, wait a minute. Now the surviving spouse, their trust has too much money in it. They're gonna have to pay estate taxes. Not true. Because when they die, they're gonna have this note that they owe, this debt that they owe, and that debt is gonna reduce their amount of the estate by the amount of that debt. So they're going to lose, that $1 million is gonna go back over into the decedent's trust. It's gonna reduce their estate tax or their estate tax, their allocation, just like it would have if it would have stayed in the decedent's trust. And then the surviving, and then that stock is actually going to get a step up in basis because it's in the surviving spouse's estate, and it's kind of amazing. I couldn't believe it when I heard it at first. I was like, no, this ain't real. This ain't working. But it kind of works, I think. So that is the answer to the question. I know it's a little complicated, but it's kind of cool. Now there are some downsides if you're in the surviving spouse. Oh, here's the other thing too. That 4% interest is going to get paid every year into the decedent's trust. So if you're $1 million, right? It's going to be 40 G's that you're going to have to transfer into the decedent's trust every year. So you have to make sure that you have some cash or something to do that, okay, to make this happen. But here's the kicker. What's going to happen is you're going to pay that into the decedent's trust, and then the decedent's trust is going to turn around and pay it right back over to the surviving spouse, because that's what the trust usually says. This type of trust directs that any income generated by the trust is distributed out to the surviving spouse every year. It's a tax thing too, crazy taxes. That's what it is. That's the answer to the Instagram question about whether or not you can execute a note against the assets in a decedent's trust by the surviving spouse's trust. Hopefully that made sense. If it did not, but you think I'm smarter, I've succeeded. If it did make sense and it sounds like something you want to talk about, that's cool. estatemeeting.com. You can book a time to talk with me in person or over the phone, whichever you prefer. If you have just regular estate planning stuff, I'm totally down with that too. Most of my stuff is not that complicated, but when the complex stuff comes along, it's kind of fun to think about and work on. Okay, so that is it. I'm Christopher Small with CMS Law Firm. If you like this video, hit the like button. If you know somebody that needs to hear this, share it with them. If you have a question or a comment, leave it. If you're not following me on Instagram at @TheChristopherSmall, go do that. And that's it. All right, so have a great day, have a great night, have a great week, everything. And I will probably be here again with you tomorrow. I'm going to try to start doing these again frequently. And that's it. So have a great night, and bye-bye.